Thank you, Ms. Lopez. Good afternoon. My name is Michael Geary, and I am lead administrative judge in this appeal of Theratest, Inc. In response to the COVID-19 state of emergency, the Office of Tax Appeals will be conducting this hearing electronically with the agreement of all parties and participants. Today's proceedings will be live streamed, and a certified shorthand reporter will also be reporting the oral hearing and preparing a transcript. The transcript and a video recording of the hearing will become part of the public record and will be posted on the OTA website. During today's hearing, we ask that you please say your name before you speak. This is especially important because some participants or observers may not have a video feed. And for this reason, please do not use the chat feature of Webex. We also ask that you please mute your microphone if you are not speaking to avoid feedback and background noise. And finally, please note that these proceedings are being broadcast live, and any information shared on the screen is publicly viewable. So to protect privacy, please do not display documents to the camera so that they could be read. Let me ask the Madam Reporter if she's ready to begin the record.
Yes, I am.
Thank you. Let's begin then. Good afternoon. My name is Michael Geary, and I am lead administrative law judge in this appeal of Theratest, Inc. Today is July 21st, 2020, and it's approximately 1:04 p.m. I am joined on this virtual dais by my co-panelists, Judges Cho and Dang, both of whom share with me equal responsibility for deciding the issues presented in this appeal. The parties will please state their appearances for the record, beginning with appellant.
Paul Raymond, attorney for the appellant. Marius, can you speak?
Marius Theodorescu.
Elaine?
Elaine Minoltowski, General Manager for Theratest Labs.
Thank you. And the department?
Chad Backus.
Mr.
Scott.
There are others, correct?
Scott Claremont with CDTFA. Sorry about that.
And Jason Parker with CDTFA as well.
Thank you, everybody. For the benefit of the shorthand reporter, can we confirm the spelling of Mr. Teodorescu's names, first and last, and Ms. Minoltowski's last name?
Let me handle that, Your Honor. It's Paul Raymond. The last name for Marius Teodorescu is T as in Tom, E as in Eddie, O as in Ocean, D as in David, O as in Ocean, R as in Robert, E as in Eddie, S as in Sam, C as in Charlie, U as in Union. And for Elaine Minoltowski, spelling is M like in Mary, I like in Ida, N like in Nora, A like in Adam, L like in Larry, T as in Tom, O as in Ocean, S as in Sam, K as in King, and I as in Ida.
Thank you. This is Judge Geary. It's my understanding that the issue in this appeal is whether appellant had a duty to collect use tax from its California customers during the liability period and to remit that.
This is Mr. Raymond. I'm losing the connection. I'm not too sure what happened.
I have the last connection as well.
Yeah, we just got locked out.
This is Judge Dang speaking. We lost Judge Geary. If we can just go off the record for a moment and take a brief recess to allow Judge Geary to reconnect.
Am I back in?
Yep.
Y'all can hear me now?
Yes, we can.
I have no idea what happened, but let's pick up where we left off. Give me a moment here. Okay, I had just identified what I believe is the issue in this matter, and that is whether appellant had a duty to collect use tax from its California customers during the liability period and to remit that tax to respondent. The liability period is July 1st, 2010 through March 31st, 2014. Mr. Raymond, did I accurately identify the issue?
This is Judge Joe. Judge Gary, while you lost connection, we actually went off the record. Would you mind going back on the record and then starting again? Sorry about that.
All right. Madam Court Reporter, you ready to go back on the record? All right. To once again identify the issue in this appeal, it is whether appellant had a duty to collect use tax from its California customers during the liability period and to remit that tax to respondent, the liability period being July 1st, 2010 through March 31st, 2014. Mr. Raymond, did I accurately identify the issue?
Yes, Your Honor.
And Mr. Backus?
Yes, Your Honor.
Thank you. The parties have submitted their proposed evidence. Appellant offers exhibits which have been marked 1 and 2 for identification, and respondent offered 8 exhibits which have been marked A through H for identification. Neither party has filed written objections to the evidence offered by the opposing party, but nevertheless, it appears to me, at least, that some of the documents offered by the parties are more in the nature of written arguments than evidence of facts. Those documents about which I have some concern have been marked are appellant's exhibits 1 and 2. One is a copy of appellant's petition for redetermination that was filed with the agency to begin the appeals process, and included with that exhibit is some facts, cover documents, a copy of the notice of determination, and a copy of a power of attorney, with the exception of the notice of determination, which has also been offered by the department as its exhibit B. It seems to me that these documents are not really evidence of disputed facts, and I'm not inclined to admit those. Appellant's exhibit 2 is entitled, let's see, I believe it's entitled Supporting Statement, and it is essentially a written statement of appellant's arguments in support of this appeal. I have the same concern about 2 of the documents that have been offered by respondent. That would be Exhibit A, which is a copy of the Appeals Bureau decision, and Exhibit H, which is excerpts from the rulemaking file for Regulation 1684. I communicated with the parties, OTA communicated with the parties by email. I let them know about my concerns, let them know that I would entertain argument if they disagreed with my intention to not admit these documents as exhibits. But I also assured them, as I assure them now, that the documents, the content of these documents will be considered by the panel as argument. Let me ask you, Mr. Raymond, first. Do you wish to be heard on whether these documents should be admitted as evidentiary exhibits, or are you satisfied that the panel will take them into consideration as argument as to your exhibits 1 and 2?
I'm 50-50, Your Honor. The reason is that in prior cases, it seems to me that the petition has been admitted as a document and evidence. I recognize that it is argument. I also recognize that it's subject to evidentiary foundation, meaning facts. I am comfortable with the fact that the panel will, and yourself, of course, will consider the points raised in argument, but it's just the first time for me that we haven't seen it come into evidence, that's all.
All right. Mr. Backus, do you wish to be heard regarding respondents exhibits A and H?
I do. So for Exhibit A, the Appeals Bureau's decision and recommendation, it includes a summary of verbal testimony that appellant gave at the appeals conference that regarding the lease of the equipment. So we are relying on the summary of appellant's verbal statements in our argument today. As for Exhibit H, it just includes, I included the language of Regulation 1684 at different points in time just to emphasize the fact that the language hasn't changed since its inception, as just to counter an argument by appellant.
So regarding the statements made by party representatives, and I assume you mean at the appeals conference that was held by the agency, you're offering the author's statements about what the party's representatives said as evidence of what they said.
Correct.
All right. While I remain skeptical about the evidentiary value of the evidence, I'm not so committed to the position I stated in my email that I'm not willing to entertain your arguments to admit those. I'll just admit all the documents, but be forewarned that, in my view at least, the documents have little evidentiary value and are primarily arguments. So I'm going to admit and will admit now all of the exhibits, respondents A through H, and the appellants 1 and 2. Mr. Raymond, you previously indicated an intent to call 1 or more witnesses. Is it your intent to call both Mr. Teodescu and Ms. Minotowski as witnesses today? I could not hear that. Is your mic mute?
Oh, I'm sorry. I remembered the instructions and they said mute the mic when you're talking. The answer is yes, I'm going to call just 2 witnesses, Your Honor.
Okay. Mr. Backus, do you have any live witnesses today?
I do not.
All right. Who do you wish to call first as a witness, Mr. Raymond?
It will be Marius Teodescu.
When we had our pre-hearing conference a few weeks ago, we talked about the possibility of having opening statements, which I would have limited to summaries of the testimony, but it's my understanding from statements made by Mr. Raymond during that pre-hearing conference that he expects the testimony of both witnesses, including possible cross-examination, to last no more than a half hour. Are you still comfortable with that estimate, Mr. Raymond?
Yes, Your Honor.
In view of the fact that the testimony is going to be relatively short, Mr. Raymond, could we dispense with an opening statement and go directly to the testimony?
Absolutely.
Thank you. In that case, did you say Mr. Teodorescu would be your first witness?
Yes, sir.
Mr. Teodorescu, see if I can, I don't see you displayed on my screen right now. I'm assuming you can hear me, Mr. Teodorescu?
Yeah.
All right.
Yeah, nice to
I'm going to ask you to please raise your right hand. Now I can see you. Do you solemnly swear or affirm that the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Raymond, you may begin your examination of the witness.
Thank you, Judge. I I'm going to call you Marius because I butcher your last name, if that's permissible, Marius.
Fine. That's fine.
All right. And I shouldn't do that because obviously at various times you've written a check to me. It's not nice when the person writing the check to you doesn't pronounce the name correctly. So I'm going to focus your attention in my questions to the time period of the audited tax periods. Okay?
Yes.
And the audited tax periods are July 1, 2010 through March 31, 2014. Okay?
Yes.
Let's take you back in time to Theratest started in 1988, correct?
Yes.
Okay. And during the time that you were at Theratest, I'm going to look at now the audited time period of July 2010 through March of 2014. What was your title at Theratest?
I was president and CEO.
Okay. And can you give us a brief description of what Theratest does, and recognize that the website I put into our argument, Exhibit 1 and 2, and I think the panel has seen it as well as the department. So just a brief description of what the operation of what Theratest does.
Theratest is a manufacturer and distributor of diagnostic products for rheumatic diseases. And one of its markets is represented by physician office laboratories, where we provided leasing equipment for the operation of the laboratory. And also we provided training of how to use the equipment. It usually takes 1 to 4 days, depending on the level of knowledge. And then sell diagnostic kits to the laboratories.
Okay, so let's break that down and talk a little bit about that. Describe for us how a typical lease agreement would work mechanically. And I'm talking about specifically California. I'm talking about specifically the audited tax period. How would that work?
The contact with the physician office is made at national conventions, and subsequently we discuss at the time of the conventions with the physician whether they desire to have a laboratory set up or to buy reagents or to lease equipment. Then an agreement is set up. The agreement many times was set up right there at the convention, so it was made in very simple language. And after that, the representative of Theratest would go to that location and train a technician of how to use the equipment. And after that, once a year or once every 6 months, depending on the complexity, somebody would go there for a couple of hours to see that the equipment is functioning properly.
Okay, let me break it down a little bit so we're all catching up to what you've said, and I thank you for your description. The first thing is how you get business, how Theratest gets business, and you said that this is a convention. Is this like a trade show that you're talking about, where Theratest displays their products as an exhibitor? Is that a fair statement of what happens?
Yes, we set up a booth where we bring the information there, and a sales representative would be there, and that's where the discussion takes place with the physician.
Let's talk about where these trade shows or conventions are held. Where are they held?
All over the country. Most of the time, probably the most frequent was Atlanta, Washington, Philadelphia, even Chicago. I don't think that during that period there was any in California, but I think last year or the year before was in California.
Okay,
So eventually it could be, but not I don't remember during that time, none of them was in California.
All right. So if I understand your testimony thus far, conventions or trade shows are held throughout the United States, correct?
All over the country, yes.
And that your present recollection is that you don't recall any in California during the audited tax periods. Is that
I don't
correct?
remember, yes. I don't recall
Okay.
any California during that time.
Okay. All right. So I assume that there's a lease agreement that's entered into between the testing center, the doctors, the physician groups, et cetera, with Theratest. Is that correct?
Yes.
And that allows for what you said earlier, Marius, about installation. So my understanding is, I'm sorry to go on a little bit, but let me just drag you into this next thought, is that representatives from Theratest handle the installation at the facilities of the doctors or the labs or things of that nature, correct?
Yes. It depends also during that time. Probably that's both the large instruments and the small instruments were installed with the help of Theratest personnel. They were shipped directly from Theratest there, and they were basically set up and turned on.
So not in every case of any leased equipment did Theratest actually provide employees to do the installation.
I think at that time, my memory is correct. Some of the it's most likely yes. Most likely yes. I don't remember the details, but most likely there was somebody from Theratest who would go after the instrument was delivered to make sure that it is properly installed.
Okay. And my understanding is that that's part of the agreement with the doctors and the.
Yes.
Okay. So let's focus on what those individuals are. They are folks that are based in, I believe you're in Lombard, Illinois.
Yes.
They work out of your office in Lombard, Illinois. Is that right?
Only there, yes.
And they come to California. They do the installation. Let's talk about how many days that installation takes. Is there an average number of days it takes?
Maybe the average would be 3 days. It also depends. It probably could be done in a very short period of time. The reason there was sometimes taking 3 or 4 days is because sometimes they have to work around the schedule of the technician availability there. So
and they would
it
leave.
Take more than a day or two, but they had to wait around sometimes.
Okay, they would leave. These installers, these employees of
Oh yeah,
Theratest,
they'll come back home.
would come back home to Illinois.
Yeah, always.
They wouldn't stay in California.
No.
They're not based in California.
No.
And I forgot to ask the question, which is the $64,000 question. During the audited tax periods, Theratest didn't have any buildings or offices or anything of that nature. Let me finish the question before you respond. Or anything of that nature at all. Isn't that correct?
No, only in Lombard.
So I am correct that they only had an office location in Lombard, Illinois. Is that correct?
Yes.
Okay. So now we have we have a limited contact of our installers. They go back to Lombard, Illinois, but under the agreements, they still provide customer support, they being Theratest, correct?
Yes, most of it was done by remote.
Well, it's done on the phone or remote. Is it done ever in person?
In person, it would be extremely unusual. The only situation that would happen, it would be if something happened with the technician and a new technician needed to be hired. In other words, which is very, very rarely.
Okay, let's leave the business of Theratest for a moment and talk about something else that you and I talked about, which is the seller's permit situation and the application. Now, yesterday I sent you and Elaine the binder. They call it a binder
Yeah,
with all the different exhibits. Do you have that in front of you on your computer? Is
it,
that easy for you to get to, or is that going to boot you
it,
out?
it would mess up what I'm trying
Okay.
to do there. And it
All
was
right.
big to print, so
Did you print it out?
no, it was way
All
too
right.
big.
So for the record, I'm going to be referring to Exhibit C, which is a, bear with me, reporter, if you wouldn't mind, 4-page document. The first page is the actual application for seller's permit. Um, you recall seeing this document, do you not, Marius?
I couldn't say that I recall. If I sign it, it means I saw it.
Okay, but
But
we talked about this the other day, right?
yes, yes.
Okay, so you know which document I'm referring to,
Yeah,
correct?
I know the seller's permit. Yes,
And I'm getting to the point of your name's on the document, you signed it, right?
yes, yes,
Okay. And on the second page of that document, there's a young lady by the name of Maureen Stapleton,
yes.
no relation to the famous movie star or starlet. And Maureen has a story to tell about how this document came into existence and how you ended up signing it along with the others. So now my question to you is, can you please tell the judges the story about what happened when Maureen approached you guys? What happened? Tell.
Basically, she told us that I have to sign a document to sell product in California, and that otherwise, if we don't sign that document, we cannot sell anymore.
Why
Uh,
did she say that? What was there anything that told her that she had to do this?
she received some information from clients that obligated her to give me the document and to sign it.
Did she also receive some information from the Board of Equalization, the State Board of Equalization?
Yes, I think that was the document about. Yes.
So the
Well,
contact was,
well, that's what I remember. I honestly I don't remember exactly, but you're right. I was looking uh, at those documents, and some of them might have been from the Board of Equalization, but I
and
don't recall.
and was it one of? Can you tell us what if there was anything about? If you don't sign it, you're going to get audited or something like
Yes,
that.
yes, yes.
Okay,
That's what I remember.
Tell us
That
in your own
basically,
words.
yeah, that we are going to have, and actually, I was actually surprised because it sounded to me very far-fetched that somebody from California would audit us in Illinois. So it just sounded to me like, really? I couldn't believe it, but I said that we'll be audited if we don't sign a document, if we don't submit that application.
So you signed the document,
Yes,
correct?
yes,
As well as the other people that are listed at Theratest, correct?
yes.
And in the section on page 1 of Exhibit C, under what, I'm sorry, my eyes are bad, what and washers. You recall that, sir?
Yes, yes.
And those
Actually,
aren't
that's
the,
how it started from initially when this information came through, because we sent a replacement part for one of the instruments.
so what you're telling me is those aren't the actual testing kits,
No,
correct?
no,
Those are completely different products.
yeah,
Those aren't the reagents,
no.
correct?
The reagents are sold separately.
And the reagents are part of the testing kits that you provide to California folks or businesses, right?
Yes.
Okay, can you briefly describe to the lay folks that are listening to this what a reagent is?
The reagents are the chemicals that are mixed together with patient blood in order to make a diagnostic test. And they on small little bottles, and they're all calculated in a way that after the reactions take place, they generate color that's entered into a computer and data is calculated and converted into a diagnostic test.
Wonderful. Thank you, Mr. Marius. At this time, Your Honor, Judge Geary, I have nothing further. I can't hear you, Judge.
Excuse me. All right, there we go. Thank you, Mr. Raymond. Mr. Backus, do you have any questions for the witness?
We have no questions.
I do have, hold on, sorry, this is Mr. Claremont. I do have one question for the witness.
Go ahead, Mr. Claremont.
I know that as part of the agreements, in addition to installation and maintenance of the equipment, it also mentioned training of the employees of your customers. How often would those trainings take place?
One time. And one time only at the time of installation. And
Okay.
and if the technician, for example, for some reason was leaving, let's say 3 or 4 years later, then a new technician would be trained.
So for each customer, there was training and installation?
Training and installation with the initial setup of the instrument, yes.
Okay, thank you. That was my only question.
All right, thank you. Let me ask my co-panelists. Judge Cho, do you have any questions?
This is Judge Cho. I have no questions. Thank you.
Judge Dang, do you have any questions?
This is Judge Dang. I just have one question for the witness. Mr. Theodorescu, during the 2010 through 2014 tax years, do you happen to know if Theratest ever filed any California income tax returns?
I would have no recollection of that. It could have been, but I honestly don't remember.
Thank you. I have no further questions.
Mr. Teodorescu, I have a couple of questions. This is Judge Geary speaking. Am I correct that the contracts, did you happen to look at the 3 exemplar contracts that were part of the respondents' exhibits in that binder?
I know the contract, yes. I know that.
And are those fair examples of the types of contracts that Theratest used during the audit period?
Yes.
Am I correct also that Theratest retained ownership of all of the equipment that was placed in the doctor's or lab offices pursuant to those particular contracts?
This was a lease agreement, and some lease agreements we retain ownership. In others, there was an option to buy for $1 at the end of 4 or 5 years, for example. It's basically the instrument was amortized and in the price of reagents. And at the end, they would buy it and keep it for $1. Most people opted to not to do that because this way they don't want to have the trouble if they don't want the instrument anymore. What would they do with it? So most of them opted to just lease the instrument and buy the reagent and pay the lease.
Thank you. And during the liability period, did Theratest sell test kits or other consumables that related to those test kits to California customers who owned their own equipment that could process those test kits?
The only reason we provided equipment is because they didn't have one. But for people who had the equipment, and this was all over the country, not just California, if they have their own equipment, we actually give them a discount because they already had the equipment.
The contracts that are exhibits refer to installation, they refer to training, and they also refer to maintenance. Can you give us an idea of what type of maintenance would be required on the equipment that you placed in customers' offices?
For the big instruments, those are the only ones who require, the robotic instruments require maintenance. And that means, depending on the size of the instrument, once a year or twice a year, somebody would go there for a couple of hours and basically tune them and replace parts that were broken, or they were obsolete, or they were something wrong with them. So basically, to make sure that the functionality continues.
The contracts that are in evidence refer to 5-year terms. Was that a typical term for an initial contract?
Yes, because also there was the term then that the ownership could also be transferred to the client if they decided to take that kind of option, like a lease with option to buy at the end of the period.
I mentioned consumables a few minutes ago, and I noted that one of the invoices that is part of the exhibit offered by respondent and admitted, they refer to something, they appear to refer to something other than testing kits. Pipette tips, for example, would those be consumables that Theratest also sold?
Yes, we were actually reselling them from the manufacturer. The manufacturer of the instrument would sell us the pipette tips, and we resell them essentially at cost with the client. So the machines can constantly consume pipette tips, so we had to make sure we provide them. They could also buy them. Sometimes they were buying it from other sources because they were available also from other sources.
Okay, thank you, Mr. Teodorescu. Those are the only questions that I have. Mr. Raymond, I should throw it back to you in case you have some follow-up.
Really don't have any redirect, Your Honor. I think we're ready to move on to the next witness.
Does Mr. Backus, do you have any follow-up?
I do not.
All right. Co-panelists, any follow-up?
This is Judge Dang. I have no further questions.
This is Judge Joe. Same here.
All right, thank you. Mr. Raymond, would you like me to administer an oath or affirmation to Ms. Mineltowski so you can examine her?
Yes, sir.
All right, Ms. Mineltowski, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give on this matter will be the truth, the whole truth, and nothing but the truth? Did you say yes, ma'am? I did not hear anything. Could you be muted, maybe?
Yes, Your Honor.
Thank you. Mr. Raymond, you may proceed.
Elaine, how are you today?
I'm good. How are you, Paul?
I'm good. I'd love to see those wonderful pictures on the left corner of my screen. It's got to be your gorgeous granddaughter.
It is.
Wonderful. We're going to be very brief, Elaine, because Mari has covered mostly everything. So let's just beginning. You started in November 2010 at Theratest?
Correct.
And you've rose through the ranks, as they say, to the position of general manager. Is that correct?
Yes.
Okay. So one of the things that I asked you to do was to research the amount of business that Theratest derived from California and other states during the audited periods. Remember we talked about that?
Yes,
And you did complete your task, I take it.
I did.
Good. Tell us what percentage of business Theratest derived from California during the audited periods.
During the audited period, it was 16%.
And were there, sorry?
16% during the audited period.
Was that considered at that point, since you were there, to be kind of a small, very small part of the business?
It's a portion of the business. We do business in 30 states.
Who would be the biggest, if you know offhand?
Texas.
Okay. And All right, well, let's talk about another subject that came up. I believe it came up either during the audit or at appeals, and that was closing out the permit. You remember that discussion?
Yes,
And so the argument was made that Theratest should have, quote, closed out the permit if they are, quote, no longer doing business in California and therefore not subject to use tax. You remember that discussion?
yes.
So what did you do to try and close out the permit? Tell the panel, tell the world out there listening on YouTube what you did.
Well, at that point, through the State Board of Equalization, we tried to close the permit, and they told us no because it was during an audit.
Did they tell you you can't close a permit while you're still in business doing an audit?
Correct.
All right. I've got nothing further of this witness, Your Honor.
Thank you. This is Judge Gary. Thank you, Mr. Raymond. Mr. Bacchus, Mr. Bacchus, do you have any questions?
I do not.
Mr. Claremont, I'll ask you, do you have any questions of this witness?
Sorry, I do. Yes, I do. I just want to clarify on one thing. When you say that statement was made to you, that it couldn't be closed out during an audit, do you mean that when did that conversation take place? Was that during the period, the liability period in question, or was that after the liability period?
It was during. We kept getting an extension on the original audit because my predecessor, Maureen Stapleton, who was the one that filled out the original application, at that point had left the company, and I had a lot going on, and I was learning a new position and so on and so forth. So the audit period kept getting extended and extended until at one point, I think it was at 3.5 years for one reason or another.
Okay. So do you know about do you have an estimate as to when that statement was made to you?
It would have been at the beginning of the audit when they first came in.
Okay, thank you.
All right, I'm assuming you're done. Let me ask Judge Cho if he has any questions.
This is Judge Cho. I have no questions. Thank you.
Judge Dang, do you have any questions of this witness?
This is Judge Dang. I do not have any questions. Thank you.
Thank you. Mr. Raymond, this, I take it, concludes your witness testimony for the hearing?
Yes, Your Honor.
All right, then we are ready to proceed with the argument portion. As discussed in the pre-hearing conference, we typically allow the appellant 15 minutes for an initial argument. The department will be allowed 15 minutes for its argument, and then the appellant will be allowed an additional 5 minutes or so in rebuttal if it chooses to use that time. So if you can begin your initial closing when you're ready, Mr. Raymond.
Your Honor, if I may, I'd suggest rather than me doing that, I will just loop my arguments at the end. We'll let the department go first, state their position, and I'll be able to state our position with any rebuttal at that point.
That's acceptable to me. Mr. Bacchus, are you ready to give the department's closing?
Yes, I am.
You may proceed.
The issue in this case is whether appellant was obligated to collect and remit use tax on its sales delivered to California customers because it is a retailer engaged in business in California, or alternatively, that it voluntarily held a certificate of registration use tax. Appellant sells medical kits, test kits, which Mr. Marius testified to. Appellant also temporarily provided equipment as a loan in connection with the sale of the test kits. Mr. Marius also talked about there were perhaps some situations where the customer already owned the equipment in that situation, did not also provide the equipment, obviously. Appellant submitted an application for seller's permit signed on May 20th, 2010 by its president, vice president of operations, and vice president of quality control, which is found in Exhibit C. By letter dated June 3rd, 2010, the department informed appellant that it was being issued a certificate of registration use tax and not a seller's permit, because appellant did not hold any inventory in California. That letter is also found in Exhibit C. During the audit, appellant provided 3 agreements for the department's review. One was a rental contract, or was titled rental contract, and the other 2 were titled equipment agreements. Those are found in Exhibit D. Appellant's agreements do not include a specific charge for the equipment, but the agreements do state that appellant retained ownership of the equipment and that the equipment was to be returned at the end of the agreement. As appellant stated at the appeals conference, which was summarized in Exhibit A, the Appeals Bureau's decision and recommendation, the charge for the equipment is built into the price of the test kits. For example, appellant stated that it might charge $4 for a test kit to a customer that is also using appellant's equipment, but would only charge $2 for the same test kit to a customer that was not using appellant's equipment. The agreements also state that appellant will provide indefinite routine and necessary maintenance on all equipment and will provide the initial training of laboratory personnel and on-site laboratory setup. And as Mr. Marius testified to, the maintenance could be once or twice a year, and then for every piece of equipment, Theratest had an employee in California for the initial setup and the initial training. And then if the technician in California, one of the customers, if that technician changed or they needed additional training, that they would set up an individual to train. Pursuant to Revenue and Taxation Code Section 6051, sales tax applies to a retailer's retail sale of tangible personal property in California. Section 6201 states that where sales tax does not apply, use tax applies to the use of that property purchased from a retailer for use in this state. Section 6203 states that use tax is imposed on the purchaser, but a retailer engaged in business in this state must collect the use tax from its purchaser and remit that tax to the department. The use tax a retailer is required to collect and remit to the department is a debt the retailer owes to the department. Appellant's sales of test kits to California customers occurred outside of California. Therefore, they were subject to use tax, which is imposed on the California customers. However, appellant was a retailer engaged in business in California at the time of the sales and was therefore obligated to collect the use tax from the California customers and remit it to the department. Section 6203 and Regulation 1684 define a retailer engaged in business in California and includes any retailer having any representative, agent, salesperson, canvasser, independent contractor, or solicitor operating in this state under the authority of the retailer for the purpose of selling, delivering, installing, assembling, or the taking orders for any tangible personal property. It also includes any retailer deriving rentals from a lease of tangible personal property situated in this state. Appellant's employees were physically present in the state to set up and install the equipment and provide training on how to operate the equipment. Again, Mr. Marius testified to this fact today. Appellant's employees' presence in California is directly related to its sales of products to California customers and enables it to maintain or expand the market for its products in this state. By installing and setting up the equipment and training the customers on how to properly use the equipment, appellant was facilitating the sale of its test kits. which are essential to the testing equipment. Thus, appellant had employees under its authority engaged in installation and selling activities in this state. Additionally, there is no dispute that appellant's leases of testing equipment, that it was leasing testing equipment. It appears that those leases were continuing sales and purchases subject to use tax measured by rentals payable. Section 6006.3 and Regulation 1660 define a lease as a contract where, for consideration, a person secures temporary use and control of tangible personal property. Here, appellant granted temporary use and control of the testing equipment as evidenced by the equipment agreements and by Mr. Marius's testimony. Moreover, the excess charge on the test kits for customers using appellant's equipment constitutes consideration for the use of that equipment. Therefore, appellant leased its equipment to California customers, and accordingly, appellant derived rentals from a lease of tangible personal property situated in this state. Each of these facts independently make appellant a retailer engaged in business in this state. As such, appellant was required to collect use tax from its California customers and remit that tax to the department pursuant to Section 6203, subdivision C2 and C3. While the foregoing is dispositive in this case, Regulation 1684, subdivision E, states that retailers who are not engaged in business in this state may voluntarily apply for a certificate of registration use tax. Holders of such certificates are required to collect tax from purchasers and pay the tax to the department in the same manner as retailers who are otherwise engaged in business in this state. Because appellant held a certificate of registration use tax, it was obligated to collect tax from its customers and pay the tax to the department. Appellant argues that it did not, in appellant's exhibits, it argues that it did not voluntarily register for the certificate of registration use tax. Ms. Elaine's testimony today was going towards that fact, and also Mr. Marius's testimony about why they initially registered or filled out an application for seller's permit. But we don't, and the department doesn't dispute that it goes and it contacts out-of-state retailers and tries to get them to come into compliance with the sales and use tax law. But appellant's contentions that its employee registered for a permit without the knowledge of her superiors ignores the fact that the application for seller's permit is signed by appellant's president and 2 of its vice presidents. Mr. Marius testified as to what Ms. Stapleton told him that the department told her, and we'll just point out that constitutes 2 levels of hearsay, and it's hard to for us to really grasp how much evidentiary value that holds. What the department told Ms. Stapleton when they contacted her to apply for a permit. Moreover, appellant's actions after being notified that it was registered to collect use tax suggest that it chose to continue being registered to collect use tax to reap the benefit of a shorter statute of limitations should appellant be audited by the department. Accordingly, even if appellant was not a retailer engaged in businesses in the state, which we have already discussed they were, it would still have been required to collect the use tax because it voluntarily held a certificate of registration use tax pursuant to Regulation 1684, subdivision E. Based on the foregoing, appellant was required to collect and remit California use tax owed by its customers on their leases of equipment and purchases of test kits during the liability period. I'll now address some contentions that were made in appellant's opening brief I'm not sure if these are still part of appellant's contentions, but because he deferred, I will go through them anyway. As to appellant's argument that section 6203 and regulation 1684 did not become effective until after the audit period began, we note that the applicable portions of section 6203 and regulation 1684 have been in effect for many decades, including in the two versions of 6203 operative during the audit period. In 1969, ruling 74 was readopted as regulation 1684 with subdivision B, including the language regarding out-of-state retailers voluntarily applying for a certificate of registration use tax. That language has continuously been included in regulation 1684 since that time, including the versions operative during the audit period adopted on May 31st, 2001 and May 30th, 2012. Exhibit H includes the language of regulation 1684 or the proposed language in 1969 and also I believe in 1985 when some minor changes were made to the regulation. Also in its opening brief, appellant discusses the United States Supreme Court opinion in the case of South Dakota versus Wayfair. Appellant states that the Wayfair opinion is not not per se relevant unless and until California adopts a statute similar to the one in South Dakota, close quote. We agree and we state that the Wayfair opinion is not relevant at all to this case. The Wayfair opinion is not retroactive and was issued well after the liability period. And the Wayfair opinion only expands on a state's ability to impose collection obligations on out-of-state retailers. It does not limit that ability at all. Accordingly, even if applied, Wayfair has no effect on a state imposing use tax collection obligation on a retailer that, as is the case here, leased property in California and had representatives engaged in selling and installing activities in California while voluntarily holding a certificate of registration use tax. Appellant also argues that its presence in California was so slight that it does not rise to the level of substantial nexus. To support its position, appellant cites to 4 cases from other states. The first is In Re Appeal of Intercard Inc. The second, Department of Revenue versus Share International. The third, SFA Folio Collections Incorporated versus Tracy, and the fourth, Bloomingdale's versus Department of Revenue. Initially, we note that appellant's physical contacts in this state exceed the contacts described in those out-of-state court cases. More importantly, In Re Appeal of Intercard and Share International are based on a substantial presence standard that has been specifically rejected by the California Court in Borders Online LLC versus State Board of Equalization. In fact, the Borders Court cites to In Re Appeal of Intercard and Share International in rejecting substantial presence as the appropriate test for the realities of 21st century marketing and technology. As such, these cases do not provide any authority in determining whether a retailer is engaged in business in California. In California, to establish a substantial nexus, a retailer must only have more than the slightest physical presence in this state. Appellant's continual and purposeful contacts in the state clearly exceed that standard, and all 3 of the independent bases for its collection obligation, which were employees selling and installing, the presence of leased property in the state, and holding a certificate of registration use tax. All 3 are well within the limits of a state's authority under the Commerce Clause. Thank you.
Thank you, Mr. Backus. Let me ask my co-panelists if they have any questions of you. Judge Cho, any questions?
This is Judge Cho. I have no questions. Thank you.
Judge Dang, do you have any questions?
This is Judge Dang. I have no questions. Thank you.
Thank you. Mr. Raymond, are you ready to give your argument?
Yes, Your Honor.
You may proceed.
Thank you. Thank you. I heard the phone ring or somebody phoned, so I paused. It's clear there are two basic fundamental issues in this case. The first is the validity of the so-called seller's permit. The second is whether, in a global sense, as Your Honor, Judge Geary has pointed out at the initial opening of our hearing today, our client, my client, I should say, Theratest, was engaged in business in California. I'm going to look at the seller's permit first because I think there may have been a misstatement by Mr. Bacchus when he said that Elaine Maltowski's testimony was talking about the permit. We actually only heard one person testify about that today, and that was Marius, who described the circumstances. I was encouraged by Mr. Bacchus's argument when he said that there is, quote, no dispute, close quote, that we do go out and try and get folks to sign up and pay their fair share of either sales and or use taxes. This has long been part of the government, meaning the State Board of Equalization's outreach program, and there are many offices of the State Board of Equalization. By the way, I'm using that interchangeably with the California Department of Tax and Fee Administration. But they've always been doing that. And that is something I think from an experience standpoint, Your Honor, and others who are perhaps have had some experience in the area have seen that. So the question really becomes twofold with respect to the permit. Was it a voluntary undertaking? Or even if it was a voluntary undertaking, were the items on the permit that were listed for, quote, sale, close quote, the actual items that were leased with respect to the use tax? I think Marius was very clear when he said that, somebody brought it to their attention and that it was a member of the State Board of Equalization. I think he was equally very clear that he felt that this was something that was not voluntary. In my petition, I'm sorry, it's either Exhibit 1 or 2, I pointed out, and I didn't ask Marius this question, but I pointed out that hindsight is always 20/20. Meaning, should they at Theratest have sought legal counsel at the time to get an opinion? Should they have, researched the matter a little bit more independently? Should they have done whatever they're supposed to do to exercise some due diligence? And again, hindsight is always 20/20, and we look back and say, coulda, shoulda, woulda, and it really doesn't solve much of the issue. So turning to the other issue on the case, and I'm not going to belabor you with the arguments about the voluntariness, et cetera. They're contained in Exhibits 1 and 2. But turning to the other issue, I think you all felt that what I was trying to drive at today, which was the limited contacts, the limited amount of contact there was here in California. That's our theme. From Elaine's testimony of 16% of the business being here in California, during the audited periods, Texas being their biggest state, to the testimony of Marius, who said, look, we had conventions, trade shows, we attended nationally throughout the United States, we had limited contact in California. In fact, I think he said he didn't recall if there was one. There may have been one. To be perfectly blunt, I don't think anybody really recalls something that occurred some 10 years ago, perhaps. So the question is, okay, we've got these rental agreements. Your Honor referred to them as contracts. I saw rental agreements, didn't see contracts. Do these rental agreements provide for any kind of contact? Sure they do. They say that the individuals at Theratest have to go to the installation site and provide the training. That was a question, Your Honor, Judge Geary, you asked. And it came out as well about the potential of some kind of maintenance. But they didn't stay in California. They didn't establish an office in California. They didn't come to California with a view of a conquering market. It was a limited contact. It was a contact that basically said, we're here, we install, we'll give you support. I believe Marius said on the larger machines, meaning the big machines, whatever those are, there was some type of maintenance that may have to take place. And I don't have my notes in front of me, but I recall him saying maybe once or twice that may have occurred. So without a sales force here, without a brick and mortar here, without something that establishes some kind of nexus, I have a really hard time looking at the case and saying, gosh, these are folks that were substantially here in California. They, they set up in mass mailings. They did things that other clients, other taxpayers have done. And for me, it's a struggle to understand how a company like Theratest, based in Lombard, could be subject to the long arm of the California taxing authorities. Um, I looked at my argument, and I looked and saw the discussion about the Commerce Clause test, and I still see, and it was in the last page of the supporting statement to the appeal, I still see the reference to the complete auto transit versus Brady site that says, despite Wayfair, it says, does the tax apply to an activity with a substantial nexus with the taxing state? And I submit to your honors as a panel that that's a troubling question for you. It should be. It is for me. Is it enough to say that we have a rental agreement? You came out, Theratest, you installed, you may have maintained. Is that sufficient enough? Or is that sporadic enough? And while Mr. Bacchus's comment about the nature of those cases that may have been rejected by California, I still think it's a different context. You have to look at it from a constitutional context and see what's fair, what's fundamentally fair here with respect to this company. If actively involved in marketing, as I alluded to a moment ago, coming to California and trying to get and penetrate this market hard, I would say to you, I wouldn't be here before you today, and I would have told the clients to pay the bloody tax and be done with it, and we're over. But I don't see that. What I sense here is very sporadic contact. So that being said, I feel that there is really no nexus. I feel that there is really no basis upon which they should be reporting either sales or use tax. A couple other little things I want to clarify, and I may be just misreading things as I get older, but what I saw was in the regulation an amendment, and the regulation 1684 amended certain things. And my point was that any of those amendments don't apply to the entire audit period. Why? Because the audit period was the amendments took place after the fact. So if one was to look at and judge the case and say, well, according to regulation 1684, the following is what Theratest should have done, I'm simply stating that anything that amended from the standpoint of September, I believe it was 2012, it's in my argument, is really not something that these amendments will be operative September 15, 2012. So you can't constitutionally say Theratest should have known about something that didn't exist until a later period of time. So in conclusion, I would ask the panel to please judiciously look at our arguments that were listed in 1 and 2, Exhibits 1 and 2. I would ask you to please consider the limited contacts that were made. I would ask you to please consider the fact that the seller's permit wasn't really voluntarily done. And I would ask you to consider the fact that even if it was done, it applies to different items, not reagents, as Mr. Murray has talked about. So with that, I am done unless the panel has any questions for me.
Thank you, Mr. Raymond. Judge Cho, this is Mike Geary. Judge Cho, do you have any questions?
This is Judge Cho. I have no questions. Thank you.
Thank you. Judge Dang, do you have any questions?
This is Judge Ding. I have no questions. Thank you.
Thank you. This basically concludes the hearing. The matter is now submitted. The record is closed. The panel will deliberate and issue its decision in due course, usually within 100 days. Thank you all for participating today. We appreciate it. OTA is going to recess for about 15 minutes while they set up for the next hearing. Thank you, everybody.
Thank you.
Thank you.
Thank you.